Let me know when you're ready. You good? Yeah. All right, thank you. All righty, whenever you're ready.
I'd like to reserve 5 minutes for rebuttal.
All right.
May it please the court, Jonathan Ellis here on behalf of S&T Bank. The trial court's decision in this case rests on 3 fundamental and reinforcing flaws. First, the trial court misapplied Ohio's liberal notice pleading standard. Under the governing precedent from the Ohio Supreme Court, Rule 8 requires a plaintiff to put forth sufficient factual detail in their complaint to put the defendants on notice of the alleged wrongdoing. A trial court should not dismiss a complaint on a motion to dismiss unless there is no doubt that there are no set of facts consistent with that complaint could lead to liability. Although the trial court recited that standard in the background section, it held my client to a much higher one akin and even greater than the federal plausibility standard under Twombly and Iqbal, just as the defendants urged it to do. Several defendants urged this court to do the same, but as the 8th District rightly recognized in Tuleta, until the Ohio Supreme Court adopts the plausibility standard or the Ohio rules change, this court should maintain the notice pleading standard. Now, to be clear, we think we passed the plausibility standard as well, but under the proper standard, we think this complaint is clearly sufficient. Second, the trial court repeatedly refused to accept as true our allegations about the defendant's conduct, knowledge, and role in the alleged conspiracy. The defendants candidly also defend that approach in this court. In their view, any allegation that does not specifically list a defendant by name is impermissible shotgun pleading and should be ignored. But that's wrong. Shotgun pleading is the lumping together of defendants with disparate roles in a case and alleging in a collective fashion in a way that makes it unclear which of the defendants is alleged to have taken which of the acts. But that's not what we've done here. We've alleged that the, quote, defendants, unquote, knowingly provided funds that prolonged and expanded Mr. Sosna's unlawful fraud, and then knowingly accepted, or more accurately took, funds from his accounts that were the fruits of that unlawful scheme.
It seems to me that central to that portion is the access that was had to the account, and then the change of the terms of the monies, you know, the acceleration of the payment period, the increase of the interest after the check kiting began.
Yeah, yes, Your Honor.
That's what I'm understanding,
I
right?
think it is a combination, yes, Your Honor,
Okay.
of the intense access they had to Mr. Sosna's bank accounts. And
So
they
it's not
could see the
about direct
transactions.
evidence, it's really about sort of, in a way, circumstantial, or the circumstances and inferences that are being drawn from that.
Well, to be clear, Your Honor, we do make direct allegations. At this stage, the question isn't what our evidence is. We haven't had discovery, and we don't have to prove our case at this stage of the case. We've made direct allegations that each of the defendants had that access, that each of the defendants knew that Mr. Sosna was engaged in this check-kiting scheme.
Well, the criminality is really directed to Sosna. You know, the fraud and so on is Sosna directly.
The fraud,
This is
yes.
all about the conspiracy. The conspiracy is then what ties it to the defendants.
That is, the conspiracy tie makes the defendants liable for Mr. Sosna's fraud. Now, the defendants themselves, we allege, have engaged in tortious interference, and that is part of the conspiracy as well. But with regard to the fraud, that's correct. But what we've alleged is that they are in a common plan, a common design to provide the funds that then extend to prolong that fraud and then to benefit, to profit from it. And we've made, again, direct allegations. And we've made a host of other allegations that make those allegations, those direct allegations, plausible, even though I don't think that's the right standard for this court. And those allegations do include, Your Honor, the access that they had, the scrutiny that they applied to Mr. Sosna's financial dealings and his transactions, and then the conduct, as you say, the repeated advances of funds well beyond what a rational defendant would do if they knew that Mr. Mr. Sosna had to support those with the nursing facilities that have a set number of beds that are failing. I think when you look at all that, it makes the direct allegations particularly plausible, particularly compelling here, certainly sufficient to get over the notice pleading standard and allow us to get discovery where we can actually have a chance to prove our allegations. And then the third error, Your Honor, on the district court and the trial court's decision.
Before you go on, part of the civil conspiracy, an element of it is that the conspiracy is acting in combination to injure another in a way not competent of one alone. So my question for you is, could Mr. Sosna have committed this bank fraud absent the MCAs?
He'd not have committed the bank fraud in the way that he did. This was a massive check.
I understand
scheme. And so it's possible to have a check kiting scheme, of course, without additional funding, but not one to this scale and not one of this duration. Now, I actually don't think that's like what that phrase means. If you look at the Gosden decision, I think it lays out that nicely. I understand what that phrase to mean is that there has to be an underlying tort. You can't find someone liable for civil conspiracy in a way that if they did that by themselves, it would be lawful. And so what that phrase means in the case is, and as Gosden does explain this, is it just means that there has to be some tortious act underlying the civil conspiracy. And here it's that fraud, and there's really no dispute. He was convicted felon of
Sure.
the fraud.
Is there an act independent, though? I mean, of Mr. Sosna's fraud? Is there an act that ties this conspiracy together other than the fraud?
Yes, it is the advancement of the funds by the defendants here. I think what the advancements do is allow Mr. Sosna to then continue this kite, to then go at greater and greater lengths, and then allows the defendants to know that they're going to get paid back in a way that wouldn't be rational if it were not for the underlying fraud. And I think both those things are enough to make them conspirators. I think the best decision on both those two decisions is the Williams decision from the Ohio Supreme Court and the Meehan decision from this court. The Williams decision is actually remarkably on point. It involves a civil conspiracy with a bank and a fraudster. And what the court said there is, although the banks were engaged in loans that would otherwise have been lawful, because they knew that they were providing funds that allowed the third party, their conspirator, to then execute a fraud, then they could be found to be in this common design and a conspiracy with the fraudster, and then liable for that fraud. And I think that's quite similar to what we have here. The Meehan decision goes on and adds slightly different facts, but makes clear that it's not just the providing of the funds that can put someone into a conspiracy, into a common design, but it's the accepting of the funds, knowing that those funds were obtained through tortious behavior. And we've alleged both those things have happened here with regard to the defendants. The third error that the court below committed is to treat our allegations, to understand them as alleging and attacking the MCA industry and their business model as a whole. And my friends have picked up that theme in this court. But again, that's not what we're doing here. I mean, to be sure, the MCA's common practices in this industry do give them remarkable insight into their clients' financial dealings, and there are consequences to that insight. But our allegations are not that level of insight, or that the business itself, just by carrying out their activities, is a tort. Rather, it is once you have that insight that gives you this bird's eye view into this massive check-kiting scheme, when you obtain knowledge that your client is engaged in this scheme and is paying your funds through the money that is stealing from S&T Bank and other banks, then you have an obligation when you make a decision to keep doing business with that individual and to keep providing funds that extend and prolong that scheme, and then accepting funds and profiting handsomely from it. That is the tort. And you don't have to do that to be an MCA lender, and that's what we've alleged in this case. If there are no further questions, I'll reserve my time for rebuttal.
Okay, I'll reserve the remainder of the time then.
May it please the court, Nathaniel Truitt on behalf of the Source Appellees. With the court's permission, I would like to use 10 minutes of our time before I defer to my colleagues. Before I address the specific arguments raised by my friends on the other side, I think it's helpful to zoom out and quickly take a high-level view of what S&T is asking this court to do. According to the allegations in the complaint, Mr. Sosna did business with the MCAs for roughly 15 months. And during the second half of that 15-month period...
I apologize. What was it that you reserved of your 10 minutes?
I'm sorry,
Are you reserving time? Never mind. Go ahead. Go ahead. Oh, this is throwing me off because it actually doesn't coincide with any of this, so it's becoming a little bit unwieldy.
According to the allegations in the complaint, Mr. Sosna did business with the MCAs for 15 months, and during the second half of that time frame, engaged in his check kiting scheme with 4 different banks, using overdraft protection that 2 or 3 of them offered to float his deficit. That's according to the allegations in the complaint. Now, of course, we know that Mr. Sosna went to jail, but there's not a single allegation, criminal or civil, that any of the MCAs engaged in any check kiting themselves or otherwise helped Mr. Sosna with his scheme. I would also add, S&T made its own business decision to honor checks that had not cleared. Now, of course, S&T is unhappy with the result of that decision, but what it has done is, with no supporting allegations, it's asked Judge Branch and now this court to support a 52 MCA conspiracy claim alleging that all the MCAs somehow, some way, were in on Mr. Sosna's scheme. Ironically, omitting the other banks who offered Mr. Sosna the overdraft protection he used to facilitate his scheme. Judge Branch got it right. Plaintiffs cannot get by with alleging speculation. And what S&T did here to hide its lack of specificity is 2 things. It offered a lot of industry-wide grievances and allegations and shotgun pleading, extrapolating random acts of 2 or 3 MCAs to all 52. And I think this point can be illustrated very quickly by looking at the 6 primary allegations that make up the complaint. Number 1, predatory practices. The complaint alleges specifically that 1 MCA has been investigated by the FTC for predatory practice. It's completely unrelated to this case, only 1. And yet, S&T goes on in at least 19 paragraphs to allege the entire industry and that all MCAs are predatory. Not only is the characterization wrong, but plaintiffs just can't get by with alleging statistics. There must be specific allegations against specific defendants. Number 2, account access or knowledge. The complaint only shows or specifically alleges that 4 MCAs had account access or knowledge, and none of those, I might add, being the Source Appellees.
It seems to me that where your arguments part is as to what the pleadings actually say. So you're saying like, oh, it was speculative. They're saying, no, it isn't speculative. These are the things that we actually put in the pleadings that have to do with the conspiracy with regard to the MCAs. So it's very interesting because the pleadings speak for themselves.
I think the issue, though, Your Honor, is that, yes, S&T alleges that all 52 MCAs engaged in the conspiracy, but that's not enough. When you look at the specific allegations, there is nothing there to support a 52 MCA conspiracy claim. Another example, one of the big ones, threats. The specific allegations show that only 1 MCA is alleged to have made a physical threat. And I might add that MCA is no longer a party. They allege that 2 MCAs made financial threats, whatever that's supposed to mean, none of those being any of my clients. And yet S&T goes on in at least 10 paragraphs to allege that all MCAs must have, upon information and belief, threatened Mr. Sosna in some way. Shared information or money, the specific allegations show that only 5 MCAs are specifically alleged to have shared information or money, none of those being my clients, the Source Appellees. Yet S&T goes on in at least 17 paragraphs And this continues. The last two, shared addresses or employees, there are specific allegations that 5 pairs of MCAs shared an address and 3 sets of MCAs shared an employee. None of those being my clients, but yet S&T goes on to allege that all the MCAs must have done that. There's one, if the court would indulge one last insight into the briefing, S&T's briefing at this court on the merits cites to the complaint 154 times for factual support. If you look up those citations, there's only 38 paragraphs to the complaint that actually name a specific MCA, and those 38 are comprised of 17 paragraphs. It is difficult to imagine any 52-party complaint of any kind that could be based off of 17 paragraphs. And that's exactly why S&T's leading argument has nothing to do with the merits. It's an attempt to contrive or manufacture an error by Judge Branch's infrequent use of the word plausible. Number one, I would just note that this pleading standard argument is irrelevant because this is de novo review. Even S&T's own case, the Sackstetter case, confirms this. In Sackstetter, the trial court expressly adopted the Twombly-Iqbal standard, expressly applied it. The second district decided that that was error because Ohio follows the pleading standard, but nonetheless said, quote, the error would not be prejudicial unless the complaint fails on the correct standard. So it's just
So
irrelevant.
what you're asking us is not to remand it for reconsideration, it's basically just to make the determination whether the pleadings pass muster.
That's exactly right.
Okay.
Yes. I would also note that the pleading standard argument is misdirection because it's non-controversial that notice pleading requires a basic level of plausibility. It cannot be that S&T can just argue at large that all MCAs everywhere are goblins conspiring to put banks out of business, and that somehow creates a claim. They must allege a specific act against specific MCAs. And it's also largely moot. Both conspiracy and fraud require a higher pleading standard, specificity and particularity, respectively.
Do you have any case law other than the Avery case saying that, Ohio-specific cases, saying that the pleading standard is higher for civil conspiracy?
The Avery case is the only case that we cited in our brief, Your Honor.
Thank you.
Finally, I would add on the notice or the pleading standard argument that it's largely theater because it's undisputed. Judge Branch cited the correct standard. It's clear she applied the correct standard. And her infrequent use of the word plausible doesn't magically create an error or mean that she decided to change the standard that she was applying. With respect to the conspiracy claim, I would just note to the court, first, there is not a single allegation against any of my clients that the anti-source appellees did any act in furtherance of it. Number two, if this court were to countenance S&T's generalized allegations regarding conspiracy, in pages 19 and 20 of S&T's brief, they cite to 4 types of allegations that they argue supports a conspiracy theory. Number 1, that they concealed their true identities, the MCAs. Number 2, that they used the same brokers. Number 3, that the MCA knew Mr. Soslin's details. And 4, that some of them shared addresses, employees, or funds. First, I would note that the first allegation of concealment of true identities only applies to one MCA, that's Avanza, who is no longer a party to this case. Number 2, I would note that much of these allegations would predate the check kiting scheme. And number 3, any reasonable inference of those remaining allegations cannot support a conspiracy claim. If using the same broker is enough, it's difficult to imagine how any limit to the frivolous claims that could be brought to the trial court or to this court just because different parties used the same real estate broker, for instance, or maybe the same insurance broker. That just cannot be enough. Any reasonable inference here is that Mr. Sosna contacted a broker asking for MCA funding, and that broker then in turn gave his information to the MCAs which contacted him. And I think one other thing I would note is that the Williams and Matthews case that S&T cites for the idea that a lender conspires with a fraudster merely by lending money to them is they're simply an opposite to this. In both those cases, the lenders transacted directly with the victim. They did so fraudulently and unethically, and they did so knowing that the purpose of the loans, which were home improvement, were never going to meet their objective because the contractor was a fraudster. In fact, on the, I believe it was the Williams case, the banks had a special name for the loan because there were so many issues. They called it the Blair loan. And yet they continued to fraudulently and unethically go out and offer these loans. Those cases, there's no speculation. There was a nexus between the lender and the victim in the transactions. This case is completely in opposite. If there are no further questions for me, I would defer the rest of my time to my colleagues.
I have one question. Did I misunderstand the pleadings? Because I understood that the pleadings stated that the MCAs changed the terms of the monies after the check kiting had begun.
I think my understanding, Your Honor, of that allegation in the complaint is that the terms became shorter term. In other words, the MCAs, I think it's clear.
That's what I understood
Okay.
as in pleadings, okay?
And so I would just offer to the court that the only reasonable inference from that is that the MCAs clearly knew Mr. Sosna was not as worthy a borrower. It doesn't mean that they're not permitted to do business with him, but like any lender, the cost of lending that money is going to go up as they seek to protect their what they're lending. It doesn't mean there's no inference there that means that they knew that he was kiting checks.
But they knew that what I understand in your response is that they would have had known about the status of solvency of Mr. Sosna. That's what I understood in your response.
I think the issue there, though, is if taken to its logical end, S&T's argument there would mean that if any bank runs a credit check and discovers that the borrower has other obligations and may not be in the best financial situation, that they're at risk for either a tortious interference or some type of claim by lending that borrower money because they now know that the borrower has other obligations, and that by lending this new amount of money, it'll make it more difficult. That's just not the law in Ohio. Lenders, businesses in general, are justified in pursuing their own business interest. It's not relevant whether Mr. Sosna was in the best financial shape or in the worst financial shape. They had a right.
And I understand what you're saying, because the illegal act is not about the lending of the money, because the legal act is about the fraud which took place at the hands of Sosna. What we're trying to assess is whether there was enough at the pleadings for the civil conspiracy, because the civil conspiracy gets you to the fraud.
I think, though, that...
So it seems as if you're characterizing the illegal act, the lending of the money, and it's like, no, we potentially have the legal act within the fraud of Sosna. It's really whether there was enough pled, and, we're talking about pleadings, whether there's enough pled to survive civil, with regard to civil
But
conspiracy.
to that point, Your Honor, the Avery case point blank says that the plaintiff must allege actual damages attributable to the conspiracy in addition to those caused by the underlying tort. As S&T has pled this complaint, that's not possible, because the only underlying tort, and they concede this in pages 23 of the brief, the only underlying tort that they argue supports a conspiracy is the fraud. And so there would be there's no set of facts here by which S&T could show damages in addition to the fraud that Mr. Sosna committed.
Well, as I understood it, and then you'll tell me whether this is sufficient. As I understood it, it's that once the check kiting began, then when the money was forwarded, the terms began to change, thereby enabling the continuance of the check kiting. So the damages is the facilitating the continual check kiting. So that's what I understood. So you can respond by, that's not in the pleadings, you misunderstood that, or you can respond by, that's not sufficient.
I think there's two issues with it, Your Honor. The first is that that's S&T's conclusion. The specific allegations show that Mr. Sosna completed his check kiting scheme by using the overdraft protection and by the fact that S&T was honoring checks that had not cleared. That's number one. And number two, it certainly is not sufficient to show some overarching 52 MCA conspiracy claim.
I don't, any questions from the panel? All right, thank you.
Thank you.
All right, yours is the easy because I have a 5-minute in here. Everything else, I didn't have anything that corresponded in here.
I appreciate that, Your Honor. May it please the court, Chad Zipfel on behalf of Appellate Knight Capital Funding LLC. As Your Honor indicated, I've been allotted 5 minutes to speak on behalf of my clients. And since Mr. Truitt spent much of his time discussing civil conspiracy and the notice pleading standard, I thought it would make sense for me to spend some of my time talking about the two other claims that appellants are still pursuing, the fraud claim and the tortious interference claim. So the core of a fraud claim, as the court knows, is a materially false representation, and to state a claim for fraud, that materially false representation has to be pleaded with particularity. That has not happened here, very clearly. The trial court issued their ruling, dismissed the fraud claim, lack of particularity. On appeal, it appears that that appellants have largely abandoned that argument, now arguing, and we heard it again here today, that the fraud claim is really at bottom the underlying wrongful conduct that gives rise to their conspiracy claim. It is still in the complaint as a standalone claim. I think it's very clear that it hasn't been pleaded with particularity. There are no materially false representations pled in the complaint being made by the appellees. What the complaint really alleges is that the appellees did regular, ordinary business with Mr. Sosna. That's what the allegations say. There are no underlying material false representations pled in the complaint. Therefore, that one can't survive the 12b6 motion to dismiss. The tortious interference with contract claim also fails. S&T's complaint fails to satisfy three key elements of a tortious interference claim. First, importantly, knowledge of the contract at issue. Second, intentional procurement of the contract's breach. And third, lack of justification. And those first two elements that we'll talk about, as we discuss them, they apply very similarly to the conspiracy claim as well. First, knowledge. The defendants cannot be liable for tortious interference absent actual knowledge or the existence of a contract. S&T failed to plead any facts that could in any way show that my client, Knight Capital, had actual knowledge of its agreement with Mr. Sosna. That's nowhere in the complaint. Nowhere. S&T simply alleges that it filed UCC financing statements and that the MCAs, including Knight Capital, should have known about it. Essentially, that's at best an allegation of construction knowledge, not actual knowledge. Thus, that's insufficient to state a tortious interference claim under Ohio law. Second, intentional procurement. Even if a Sosna entity breached the contract with S&T, there are no allegations in the complaint suggesting that any of the appellees intentionally designed the contract's breach. To show that intentional procurement, S&T has to demonstrate that Knight Capital or any of the other appellees was also aware of the terms of that contract and knew that their business would likely precipitate a breach. That's the Ohio law.
Is there any allegation that there was an event of default before the MCAs took any money from the accounts or during that time?
I don't believe so, Your Honor. It is a 271 paragraph complaint, so I don't have it all memorized, but I don't believe there's an allegation in there that the appellees were somehow knowledgeable of a default by Mr. Sosna or in any way, shape, or form. What the complaint really alleges is that the MCAs did business with Mr. Sosna like they've done business with everybody. That's what the complaint alleges, that they made loans, that those were, they're not necessarily loans, they're purchasing accounts receivable, right? And they do business with Mr. Sosna the same way they do business with everybody. That's the MCA industry. That's what the complaint really is about, is complaining about the way the MCA industry operates. That's what it really is. This is a traditional bank complaining about the way that the MCA industry operates. That's what we've got. So there is no evidence or there is no allegation of an intentional procurement in the complaint. There's nowhere in the complaint does it say that Knight Capital or any of the other appellees knew about the agreements between S&T and Mr. Sosna, intentionally did something to cause him to breach it. That's not what they allege at all. What they allege is that they purchased the accounts receivable, and that by the very nature of doing that allowed Mr. Sosna, or Mr. Sosna was then able to use that money to somehow further facilitate his check kiting scheme. How exactly that happened is a little unclear in the complaint, because as my colleague indicated, the real allegation is that checks were written off of overdraw protection accounts and deposited by S&D. Nonetheless, the allegation is that funds from the MCA somehow facilitated that. But there is no evidence, there is no allegation of any intentional procurement. That's a base element of a tortious interference claim. It's not there.
All right, thank you. I do have one quick question.
Yes, Your Honor, of course.
With regard to tortious interference, the complaint allege any resulting damage?
Well, I would admit that in a way it sort of did. They have alleged in an overarching manner that they've been damaged as a result of Mr. Sosna's check kiting scheme. So I would imagine they would argue that. I don't think they've alleged any damages directly related to the conduct of the appellees. Because again, they've not alleged that we knew about those contracts or that we intentionally procured them, or intentionally procured the breach of them. So the complaint
That's
doesn't
why I'm
tie
asking.
other than a baseline.
I'm not talking about the fraud, I'm just talking about
Right.
just the tortious interference, whether there is any allegation of resulting damages as a result of tortious interference.
I believe that other than the bare paragraph that would be at the end of the count in the complaint that says we were damaged as a result thereof, I don't believe it's in there. There are no supporting facts, no supporting allegations to show damages related in any way to the tortious interference.
Thank you.
Unless the court has any further questions, I'll surrender the rest of my time to my colleagues.
All right, thank you. Good morning. All right, again, no issues with the timer.
5 minutes.
You can relax.
Nothing.
I got you covered, 5 minutes.
Right. May it please the court, I'm Paul Kerridge. I represent 4 of the MCAs. It's Green Fund of Manhattan LLC, YRB MCA Inc., KeyCap LLC, and Bridge Funding Cap LLC. So I have 5 minutes, and I'm going to try and touch upon 3 issues, but I'm going to do it super briefly as much as I can. First one is, I'm not going to restate what you've just heard. My clients join all of the arguments raised about the pleadings and the standards.
Understood.
The second part is I do want to spend probably the bulk of my time talking about proper application of the standard for a motion to dismiss. And then I think I'm going to touch upon personal jurisdiction. There's an alternative argument raised in the brief. It's just an alternative argument if you're not reversing.
And no one has really addressed personal jurisdiction yet.
I'm sorry?
I haven't heard anyone address personal jurisdiction
Right,
yet.
but I would just rest on my brief. I don't think there's anything I'm going to say that isn't in the
Okay.
brief on that. So let's turn to the pleading standard, and I admit this is a little bit of a steep climb, but I'm going to try and convince you that Ohio has actually always had Twombly and Iqbal as the standard. So give me a couple of seconds, and I'll try and explain this based on the historical application.
I
of
wish
the
someone
standard.
had told us that.
Yeah, well, so I think someone might have done in very vague language that has slowly been developed over the years. So 1957, Conley versus Gibson, United States Supreme Court, uses the phrase something along the lines of no set of facts. And everybody starts moving forward with this, and Ohio adopted that case, Conley versus Gibson, the 1957 US Supreme Court case. Ohio adopted that in 1975. So since 1975, in fact, in the syllabus of the O'Brien case, which it actually says Conley versus Gibson followed. Now, what happened then is, whatever it was, 30 years later or something, we got this Twombly versus Iqbal decision. And everybody uses this shorthand of heightened federal pleadings. That's the shorthand we use. But what Twombly did is well, let me say it the other way around. Twombly didn't change anything. What Twombly did was explain that courts had misapplied Connolly versus Gibson, and that the plausibility standard had always been the rule under Connolly versus Gibson, and other courts had misunderstood that. And then from now on, apply Connolly versus Gibson properly. Now, there's a concurrence written relatively recently by Justice DeWine explaining all of this in much better than I ever could, which is why if you read that concurrence, it will look remarkably similar to one of the sections of our brief, because I basically copied it. Because it seems right that Connolly versus...
You practically adopted it, how's that?
Yeah, sure. I would give Justice DeWine more kudos than that, but sure, I'll accept that. So what we get to is the plausibility standard that is explained in Twombly versus Iqbal is not a new standard. It is the standard that was set forth in Connolly versus Gibson. And when the Ohio Supreme Court adopted Connolly versus Gibson in 1975, the Ohio Supreme Court didn't adopt the misinterpretation of Connolly versus Gibson. The Ohio Supreme Court adopted the proper interpretation of Connolly versus Gibson. And all Twombly and Iqbal did was explain what that proper interpretation was, which is the claim has to be plausible. We can't have, so-and-so punched me on the nose, and by the way, they also conspired with aliens to do it. So sure, I might have made a plausible allegation of being punched on the nose, but I think we can probably get rid of the alien conspiracy claim, even though theoretically I guess I could prove the existence of aliens. I mean, there is a set of facts, but no one's going to allow that claim to move forward because it's not plausible. So what I think we end up with is the standard in Ohio, we use this phrase notice pleading standard, but all that Twombly did was explain what notice pleading means. It didn't change it to a heightened standard. It explained that plausibility has always been part of the notice pleading standard. And courts, if you read the big chunk of Twombly explaining exactly why Connolly used the words it did, and it was basically because there was a whole section before the no set of facts standard saying these allegations are plainly plausible, and therefore it sort of moved past the plausibility analysis before it got to explaining the no set of facts standard, and it was the no set of facts standard that was quoted by a bunch of courts in isolation, and that led to this misunderstanding. So I'm going to try and sum this up in one snappy sentence if I can. Ohio Supreme Court adopted Connolly versus Gibson, adopted the correct interpretation of Connolly versus Gibson, not the incorrect interpretation of Connolly versus Gibson, and all Twombly did was explain that, explain the proper interpretation of Connolly versus Gibson. So when Ohio adopted Connolly versus Gibson, it really adopted exactly the standard that is explained in Twombly. So if you get to the point where you're doing a de novo review of the claims, because you sort of have this problem with the use of the word plausible, I think that de novo review is done through the lens of Connolly as explained through Twombly, not Connolly as misapplied. And that's all I have to say.
So that which is pled must be plausible?
Yep.
Okay. So is there anything that's pled that's not plausible in this case?
Well, then you would just go back to what I would just say, like the decision, Judge Branch's decision sets forth the claims that are, Judge Branch applied the notice pleading standard in the, let me get this the right
Understood,
around.
but,
Yeah.
but your friend, Attorney Truitt,
Yeah.
basically said this is de novo.
Right.
It doesn't matter if the wrong standard was applied. I'm not asking you for you to remand it for the trial court to redetermine. I'm asking you to determine under the correct standard. You are now explaining to us what the correct standard is.
Yes.
My question is there anything in the pleadings that's not plausible?
Yeah, a 52 MCA conspiracy for people that are never alleged to have discussed anything with each other, that would be not plausible. And like a silent conspiracy, a conspiracy with no communications, that would be not plausible. I think it's a 200-count complaint. We could go through all of these, but that's just an example. The idea that...
So what you're saying is in order for there to be a conspiracy, there must be actual communication about whatever is at hand with the conspiracy. There has to be actually,
Well, I believe the
true
I'm sorry, I interrupted.
communication. There must be a discussion.
I believe the standard is there must be a common goal.
There must be, as partner,
Common goal.
a common goal.
Goal, that's conspiracies require a common goal. And that would be absent if there's, yeah, I think I've satisfactorily answered your question.
Alrighty.
Okay, thank you so much.
Okay, we do have a 3-minute one.
May it please
Although
the
my
court.
battery's low, apparently, I just got a notice on that. The timer and I are not best friends right now. You can start whenever you're ready.
Thank you, Your Honor. May it please the court. My name is Dylan Gould from Markovitz, Stock and DeMarco, who represent Appellate, Eincap, Inc. And I join in the legal arguments that have been made here today by counsel for the other defendants. One legal point I would like to make, I think there was a question whether Avery is the only case that's been cited that discusses a specificity standard. I believe in our brief, we do cite another case for a similar proposition, which is Cleland v. Wildermuth. It's a 10th District decision. It's 2011, Ohio 6390, and we cited paragraph 20. And although there's a specificity standard for conspiracy claims in general, here the conspiracy claims are conspiracy to commit fraud. So fraud is always subject to a particularity standard, and the case law in conspiracy to commit fraud claims discusses often how those claims are going to be held to a higher standard than just even a traditional conspiracy claim. Now, I really just want to take a minute to stress, kind of switching gears here, to stress the lack of well-pleaded allegations in the complaint about Eincap specifically. All the complaint really alleges, the only substantive allegations in the complaint about Eincap are that on one occasion in January of 2020, Eincap provided MCA funding on one occasion to Harold Sosna or to some other unidentified entity. It's not really specific. There's really no indication from the complaint that the decision to provide funding was anything other than an independent business decision. Now, the complaint includes, plaintiff tries to suggest otherwise by, for example, including an allegation that Eincap has an office on the same floor of a building in New York City, in the financial district of New York City, as one of the other defendants. But that's not even circumstantial evidence of a conspiracy between the defendants, let alone evidence of a conspiracy between Eincap and Mr. Sosna.
So as I understand your argument is that having shared space, or even if there was shared space, even if there was shared employees, that's not sufficient.
Your Honor, I don't believe there are any well-pleaded allegations that Eincap shares any employees or personnel with the plaintiff. And yes, Your Honor, I think the mere allegation that there was a shared building floor is not sufficient for a conspiracy, and although not directly relevant here today, discovery would show that there was no relation between the parties. And, more than that, the complaint alleges that the money was paid back to Eincap in April of 2020, but any alleged losses to S&T occurred weeks later in May. So any fraudulent conduct by Mr. Sosna that actually caused these alleged losses would not have been for the benefit of Eincap. I believe there was a question earlier about whether there had been defaults prior to these instances of funding, from the conventional lenders. And I don't have the specific paragraphs in front of me, but I do know specifically in the complaint that it alleges that Huntington Bank and FFB declared defaults in February and March of 2020. But again, Eincap's money was provided in January. So at the time Eincap provided funding, Mr. Sosna was still in good standing on these massive loans with multiple conventional lenders.
So just so you know, your time has run. I'll give you 30 seconds if there's any last point you want to make or if you want to wrap up.
Thank you, Your Honor.
Okay.
I'll wrap up quickly. I'll just point out that there are hundreds of pages of exhibits attached to the complaint. Not one of those references or mentions Eincap in any way. Really, all it shows is that one time Eincap provided money to Harold Sosna or to some other entity, and that money was paid back before any damages were incurred by S&T Bank. That's not sufficient to state a claim.
Thank you.
Thank you.
All right. All right, if I've done my math right, you have 16 minutes.
Okay.
And there is no 16-minute timer thing here, so
That's, well,
we'll muddle through it.
I doubt I will have 16 minutes of things.
What I've been doing
say,
is
but
just
happy to
using
answer the
2
questions.
entries and having them.
I do want to make, no.
Do you think Ohio has adopted that Twombly standard?
Well, so I was
Is that
going to
what
say
you're-
3
okay.
points. First point is what this pleading standard was. So I think no. It answers it has not. I think if you look at what Twombly and Iqbal did, it very clearly retired the no set of facts language from Conley v. Gibson that the Ohio courts have adopted. And if you look at federal court cases post-Twombly and Iqbal properly applying that standard, you will not see the no set of facts language. You will not see that standard. I think it sort of blinks reality to say that the Iqbal and Twombly standard is not a raised one from the one that had been applied in federal court. And I think it is a raised one of the one that is properly applied in Ohio courts post-Twombly and Iqbal. The Ohio courts, including this one, continue to use the no set of facts language as the standard. As recently in Maternal Grandmother, the Ohio Supreme Court used that language and applied that standard. I think the 8th District decision in Tuleta lays out very clearly that it is left to the Ohio Supreme Court or the rules, a rules change to adopt that higher standard. I think if you look at the DeWine concurrence in Maternal Grandmother, what you'll see is that Justice DeWine was acknowledging that that court had not decided whether to apply the plausibility standard. There are certainly some things that remain consistent. The legal conclusions don't have to be credited. Factual allegations do. That has always been the rule in federal court, and it is the rule in Ohio courts. But the plausibility standard, the heightened plausibility standard, does not apply in Ohio courts.
Well, how would you respond then to your opponent's arguments that both the Avery case and the Clellan v. Wildermuth case, which I'm looking at right now, both of those cases say that conspiracy claims must be pled with some degree of specificity?
So I take that to be a slightly different issue, Your Honor. I think that is about whether it's kind of a Rule 8 or some sort of Rule 9 equivalent. I think they're misreading those cases. If you look at Avery, for example, what the court says there, it's a 6th District case, that there are no facts in that allegation about the damages from the conspiracy. There's no allegation of a tort, an underlying tort in that case. I think they're plucking out a language that I credit you could suggest that there's some sort of particularity requirement, but I think the actual requirement for conspiracy is the Rule 8 notice pleading standard. Rule 9 is about fraud, of course, not conspiracy. And for that, I think you need to allege the object, the purpose, and the damage, and we've done all of that. We've done all of that here. Now, I actually don't think that the court needs to spend a great deal of time on the pleading standard. I do think that's the proper one, and we meet it clearly. But I also think that this complaint passes any plausibility standard as well. Now, just taking a step back, I mean, defendants are clearly on notice as to what we have alleged. You heard them stand up today and say that we allege this conspiracy among 52, it's 51, it's actually a little bit hard to count, how many MCAs we alleged, we named one in the complaint that then one of the defendants came back and said, no, that's the same entity as us. So it's a little bit hard to figure out exactly how many distinct entities there are here. But they complain that we have alleged a conspiracy among all these organizations. We've alleged that they had access to Mr. Sosna's funds. We've alleged that they've entered into and they've made these advances with the purpose of advancing that fraud and profiting from that fraud. That's true. That is our allegations. That they're clearly on notice of what we have alleged that they have done. They just dispute that they have done it. Now, as
So
to
central to that is the knowledge, the access, the knowledge, right?
yes, Your Honor.
Now, aren't there some of the defendants that didn't have that access and knowledge?
No, so at this stage of the case, we have alleged that they all had that access. You can look at paragraph, 113, we said that the defendants, all of them, logged into Sosna's accounts to schedule ACH payments. We've alleged at paragraph 122 that all of them intensely scrutinized Sosna's and his entity's finances. We alleged at paragraph 123 that all of them were acutely aware of the business's financial situation. And we alleged at 168 that all of them repeatedly informed Sosna that they were closely monitoring all of Sosna's and his entity's bank account history. We have made the allegations that all of them had this access, that all of them were exercising this access, that they were in agreement and a common plan in order to advance this fraud. And so the question really is, have we met, going over whatever barrier, whatever burden it is, to show that it's not speculative or that it's plausible, depending on which standard you want to apply. And I think we've done both. I mean, this is not a case about the entire MCA industry. At paragraph 126, we allege that all of these MCAs made advances to Mr. Sosna. So this is not the entire industry as a whole. And this is not an allegation about goblins coming down or whatever the metaphor was. This is allegations about an industry that has some bad apples in it. It has been the subject of investigation, has been the subject of allegations.
And I assume that you do acknowledge that simply providing the advances is not sufficient.
I'm sorry, Your Honor?
I assume that you acknowledge, you can say no, okay, that merely making the advances is not sufficient.
I agree, Your Honor. I think for a conspiracy, you've got to have a common plan. You've got to have an agreement, either explicit or implicit. It doesn't have to be an explicit agreement. But I think what the Williams case shows is that when you make an advance or a loan in that case, knowing that what those funds are going to be used to do is to carry out a fraud, that's sufficient to show that common plan and that common design. I think that's certainly sufficient at the pleading stage to get us to discovery, so we can actually get in and understand how these advances worked, what the communications were, what they knew. Eventually, we will have to make our case. Eventually, we will have to prove the allegations that we've made, but they're clearly on notice of what they are, and I think they are more than plausible that that's what occurred here.
So the other traditional lenders, they also lent money to Mr. Sosna, millions and millions and millions of dollars, also had the float. So is there any allegation that the traditional lenders
We have
acted?
No, we have not alleged that they knew what was going on, and I think there's a couple different reasons for that, Your Honor. The first is that traditional lenders don't have this sort of bird's eye view, this sort of ongoing access where they can look at all of the accounts of Mr. Sosna at any time, where they can pool the funds at any, on a daily and weekly basis, these large amounts of funds.
So the
one is the
contract
access.
between the traditional lender and Mr. Sosna did not include the access to the accounts.
I'm sorry?
Is that what you're saying?
Yes.
That
Yes.
the
So there's
contract between-
two distinctions, I think. One is, and it's a big one, right, is the access and the knowledge that the MCAs had into Mr. Sosna's financial dealings
But
because
the
of the way they
knowledge
operate.
that you're calling access and knowledge, but as I understood it, your knowledge is an inference from the access.
We actually allege in explicit words that they had knowledge of his financial dealings. We actually allege that they scrutinized that. The question really is that a plausible allegation, right? And I think it obviously is. I mean, if you look at the second thing that distinguishes the MCA, the defendants here, from traditional banks is the series of loans that were made, the increasing amounts, the shortening period, and just the amounts as a whole, right? We're talking about Mr. Sosna, a man who is operating failing nursing
So let me rephrase my question.
facilities. Sure.
So it's the access and the increasing of the terms of the repayment, and I believe also the interest,
The amount of the
the amount
payment
of the
as well.
interest after the check kiting begins is what creates the inference of the
I
knowledge.
think it's what makes it plausible. I really don't think this court needs to infer anything. We have made the allegations. We have alleged the defendants knew. We have alleged the defendants agreed with
Okay,
each
then
other.
let me rephrase that. Are there circumstances that support the knowledge?
Yes, Your Honor.
Okay.
That's correct. That's
All
correct.
right?
Just to say a word about fraud and about tortious interference. And I'm happy to address personal jurisdiction if the court has any questions on that as well. On fraud, we do have a standalone count. The reason we have a standalone count is because, for two reasons. Below, of course, we alleged both that they are responsible for Mr. Sosna's fraud that no one disputes occurred, and that's because of the conspiracy, but that provides for a separate cause of action for fraud against the defendants. They are liable under Williams for their co-conspirators' fraud that no one really disputes occurred here. Below, we also alleged that there was a separate fraud from the MCAs, by the MCAs, that is the misrepresentations, the concealing of their loans by holding back the UCC filings. We haven't rested on that here. We haven't abandoned that, but I think it's sufficient for our fraud claim that we have alleged and plausibly alleged a conspiracy that makes them liable for Mr. Sosna's fraud. As to the tortious interference, Your Honors, I think we again have made the allegations sufficient to make out a claim for tortious interference, and they are on notice that that is what we have alleged. I think there was a question about the damages.
There's a question about damages, resulting damages from the tortious interference.
Correct. So I
is my
think
question.
Right, and the damages that we have alleged, you can look at, it's paragraph 270 of our complaint, and what we said is they have deprived us of our collateral. They have taken all of the accounts receivable that we had a priority interest in a way that once the inevitable default came from Mr. Sosna, we could no longer collect on that. And they did that knowing that we had a priority interest on that, on the accounts
But
receivable.
at the point that they took that money, there was no event of default, correct?
There had not been an event of default, that's correct.
So if
At least that's the allegation.
okay, so if there was a lender or any sort of creditor who took from that account, let's put the MCAs aside for a second, that took from that account knowing, if they actually knew that there was a security interest there before an event of default, how would that translate to interference?
So I think you've got two different things going on there. I mean, one is the conduct that you actually damage us, and I think there's a distinction here in that we've alleged a conspiracy. They are working together, and they are draining these accounts of any value, not just exercising one withdrawal, but a series of daily and repeated withdrawals that drain them of account. Two, they have the knowledge of the priority interest. And then three, I think what's important here is that tortious interference has to be unjustified. And so I think the court does have to say, have we plausibly alleged that what they did here was not justified by their own business interests? And I think we've made that case, at least at the pleading stage, that it's fine to exercise your loans when you're not acting in conspiracy to further this series of loans and advances that suck these things dry of any value. It is not justified when what you're done is work in conspiracy to allow and to benefit from this series of loans, from the misconduct by Mr. Sosna, and pull that money in, leaving us with no collateral at all.
Thank you.
If there are no further questions, I'll just close with this, Your Honor. I think what was clear from the briefing and from the arguments is that the MCAs deny our allegations. They think it's not plausible. They think they're not in conspiracy together. They never were. They were merely exercising their business. They're, of course, entitled to deny all of these allegations. I think there's no doubt that they know what we've alleged, and I think the problem in this case is that we haven't had the ability, the fair chance, to get discovery and to prove those allegations. At a further point in this case, if we can't prove them up, then they can defend and individual MCAs can get out of this case. But for now, I think we have made the showing that's required by Ohio law to get just to discovery and to have a chance to prove our case. So I'd ask the court to reverse. Thank you.
All right, thank you. Thank you to all counsel for your arguments this morning. We will take the matter under submission, issue you a timely decision, and I wish everyone a wonderful afternoon and a great week. And with that concludes our proceedings for today. Thank you.